Welcome to literary and jury charge practice. Let's get started with some literary material. It's called Practice. It's a necessity, not an option. Ready? While there are many schools of thought concerning the methods and how much time reporters should spend practicing, what is very clear is daily disciplined practice sessions leads to student success. Leaders should think critically about how to deliver the structure that provides the greatest opportunity for achievement and the best outcomes for students. I firmly believe that the purpose of systematically thinking about practice is not to establish a one-size-fits-all model for practice, but simply to determine situationally what works to help students to achieve at their individual level. In my perfect world, learning rather than practice or seat time will be the core measure of progress, and students will be able to demonstrate in dynamic environments what they've learned from outset through to proficiency. What's more, I'm in accord with Humphrey Sontag's assertion: practice does not end when you graduate. Most professional reporters and captioners continue to hone their skills through regular practice and continuing education regime throughout their careers. I assert that practice beyond school should be viewed not as a static, one-time experience, but as a lifelong journey of building one's knowledge and skills. As I reflect on my journey toward piano mastery, I realize the importance and necessity to practice regularly. It was during my tenure at McCormick College that I decided to try again. Witnessing the hard work and dedication of court reporting students gave me the inspiration I needed to take practicing seriously. At times, when I'm dragging to get to my instrument, I often think about the time and effort court reporting students are putting into practice, and that gets me motivated. I have found my music again. I have court reporting to thank for that. Let's get back to some jury charge work, jury charge practice. And the subject of this jury charge is duress. Ready? It is for you to determine from the evidence in the case whether or not any valuable consideration was given to this defendant for this instrument. If you find from the evidence that the instrument was not given for any valuable consideration, then plaintiff cannot recover, and your verdict should be in defendant's favor. The second defense set out is that this instrument was obtained under duress. Duress may be defined as the coercion of one person by another by means of bodily restraint, threats of serious injury, pressure or constraint to such extent as to virtually take away the free agency of the person threatened, and compel him to go against his will, and destroy his power of refusing to comply with the unlawful demands of another. Duress is a species of fraud in which compulsion in some form is the means employed. A note of contract obtained by duress cannot be enforced in an action of this kind. The burden of proof in this case rests upon the defendant on each of these two defenses to prove the same by a preponderance of the evidence, that is, by a greater weight of the evidence. Now, if you find from the evidence, under the rules given you, that this written instrument was given for a valuable consideration, and that it was not obtained by duress, then you should find a verdict in favor of the plaintiff for the amount claimed plus interest. On the other hand, if you find from the evidence, under the rules given you, that there was no consideration given for this instrument, or if you find from the evidence that this instrument was obtained from the defendant by duress, then in either such case you should find a verdict in defendant's favor of no cause of action. Back to some literary material. Ready? In the midst of the hiking excursions, and after my blisters had blisters, we took a day at the Indian Hot Springs Spa, complete with mud baths and mineral springs. Everyone was genuinely blissful and engaging. It reminded me of our conventions and the camaraderie I have with all my fellow reporters, captioners, and students. One profound encounter I had was during a hot bath in a cave next to a gentleman who turned out to be an attorney who lives in Bradenton Beach, Florida, just a stone's throw away from where I live in Sarasota. Just like the court reporter and judge I met on the plane, we were put in each other's paths for a reason. He was on a bucket list adventure that ended at this spa in Idaho Springs, a town in Colorado that was once the boom of the gold rush and mining, with his friend and holistic doctor, after being diagnosed with stage 4 colon cancer. It was the last day of a trip that he had been on for several months. The Bradenton Beach man had had a minimal amount of chemotherapy months before his trip, but according to his doctor friend, he is now cancer-free. He credits the time spent nourishing his body, mind, soul, and spirit, and ridding himself of the stresses that he believes were ultimately responsible for the cancer. Meeting both of those men and hearing their stories solidified my awakening that this trip was so much more than just a physical adventure with amazing scenery. It was also a spiritual journey, taking me full circle to the beginning of this article. We are people first, people who need to stay well for our minds, bodies, souls, and spirits. That will not only make us better people, but better reporters, captioners, parents, spouses, and children. You do not have to travel away from home to nurture your spirit. The answer may be right in your own backyard. Maybe the food for your soul comes from petting your dog, going to yoga, or just simply hugging the person who you love the most. For me, the enrichment started with the adrenaline rush of the climbs to the top and the returns to the bottom without hurting or even killing myself. It finished with the personal connections I was able to take home as my most treasured souvenirs. The subject of this jury charge is unlawful seizure. Ready? Ladies and gentlemen of the jury, one of the inalienable rights of the individual citizen is the immunity from the unlawful seizure and detention of his person by any agency of the state. You are instructed that the general rule of the law is that no person shall be deprived of his liberty except he first be charged by affidavit or indictment with the commission of an offense, such charge being followed by a warrant duly issued and placed in the hands of an officer authorized to serve such process. To this general rule, there are certain exceptions made necessary by the needs of society. Among the exceptions is that an officer may arrest a person without a warrant for an offense committed within his view or upon information when he has reasonable or probable cause to believe that such person has committed a felony. When a police officer arrests a person without a warrant upon information when he has reasonable or probable cause to believe that such person has committed a felony, it is the duty of the officer to take the person whom he has placed under arrest before some court of proper jurisdiction as soon as he can reasonably do so, to be charged with such offense by affidavit, or to be given an opportunity to be released on bond. If the officer fails to take the person so arrested before a court of proper jurisdiction, as required by law, or gives him no opportunity to be released on bond, then he is liable to such person in an action for damages. You are instructed that the power of detaining a person arrested without a warrant upon information, or restraining him of his liberty, even when there is reasonable or probable cause to believe that such person has committed a felony, is not a matter within the discretion of the officer making the arrest. He cannot legally hold the person arrested in custody for a longer period of time than is reasonably necessary under all the circumstances without a warrant. Mere loss of freedom cannot constitute imprisonment, even though it was unjust. The imprisonment must be unlawful. One may be acquitted upon the merits of the case or discharged under some question of law, but that fact does not, in and of itself, make the restraint placed upon his liberty false imprisonment. Ladies and gentlemen of the jury, if you find for the plaintiff, you are instructed that wounded pride, humiliation, and mortification resulting from the public arrest and the public trial are elements to be taken into consideration in assessing damages in cases of this character. You are further instructed that in case of false imprisonment and malicious prosecution, the jury may inflict exemplary damages when the facts so justify. Such damages do not necessarily depend upon malice on the part of the wrongdoer, but they may be rightfully awarded when the wrongful act is willfully done in a wanton or oppressive manner, or done in the reckless disregard of the rights of the complaining party. Write a little more jury charge practice. The subject of this jury charge is plea for mercy. Ready? May it please the court, if there is any single attribute of American jurisprudence which makes it above that of any other jurisprudence in the world, it is the ability of the court to maintain an open mind and a dispassionate attitude until it has heard both sides of any given situation. Your Honor, we have here a 22-year-old boy, a boy who has not previously been guilty of any crime of any nature whatsoever, who has never been accused or led before the bar of the court for any crime whatsoever. Your Honor, his mother is in court this morning, also his stepfather and his wife. Had it not been for the space of a few brief moments in the particular evening in question, this boy would not be before the bar of this court, charged with the most serious crime on our statute books, the crime of murder. This boy has consistently adopted an attitude of contrition and sorrow and penitence for his act of that night. witness the following, Your Honor. He gave himself up. He didn't have to be sought out and picked up by the police. He didn't cause the police to search over the community for him. He gave himself up voluntarily to the police officers, and of his own free will and volition gave a statement to the police officers in the presence of Clifford Morrison, withholding nothing, telling everything that he knew, completely penitent, completely contrite. Your Honor, much has been said, making light of the Prohibition Act, the Volstead Act. If ever there was a justification for the act and its rigid enforcement, that justification is before Your Honor this morning. Here is a 22 years old, a boy. If he hadn't had 15 or 20 shots of whiskey in him and maybe a dozen beers, this boy would not be before the bar of this court this morning. And that will conclude our literary and jury charge practice.